Hi, students. Okay, so today we're going to do a mini lecture on search warrants. So consider this search warrants part 1, and then we will continue our lecture during our Zoom class. Let's get started. You should have the PowerPoint in front of you. So a search warrant is just a court order signed by a judge to allow the police to search in a specific place for a specific item at a specific time. It's based on the Fourth Amendment to the Constitution, and of course the Texas Constitution mirrors that as well. But I'm going to read it because this really does adequately describe what a search warrant is. It reads, "The right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated, and no warrant shall issue but upon probable cause, supported by oath or affirmation, and particularly describing the place to be seized and the persons or things to be seized." So here it says no warrant shall issue, but you have to have probable cause. There has to be some kind of affidavit, and there's a particularity requirement where you have to particularly describe the place and the persons or things. There's also a preference in the law for search warrants. In fact, the law says that anytime you do a search without a search warrant or without the prior approval of a magistrate, it is per se unreasonable unless it's covered by one of the few exceptions. And here are the exceptions here, which you may have already studied when you took criminal procedure. So let's talk about who's involved with a search warrant. You have the police officer. The officer is the one who's responsible for providing the facts that will lay out the probable cause in the affidavit. The prosecutor is actually typically the person who drafts the search warrant. So it's really important for those of you who are interested in criminal law to know what it looks like and how to draft one. The magistrate judge is responsible for determining if the facts actually constitute probable cause or not. So search warrants have gotten a lot of publicity in the news lately, and certainly they're seen sometimes as controversial when we think of the death of Breonna Taylor that is still being investigated, which involved a no-knock warrant. And there have certainly been other tragedies that have happened. It's also a very important tool for law enforcement. So as we look at both sides, I'd like to read this quote. It's described by one author as nothing less than an armed invasion into the sanctity of the home. I think regardless of how you view search warrants, you need to really think about the serious risk involved, whether you're a judge who's signing off on it, or a prosecutor who's drafting it, or a defensive attorney who's trying to challenge it, because there really is a lot of power in that document. The law is complicated, and the risks are real to everyone involved. There are risks to innocent civilians, risks to law enforcement, and risks to the evidence being sought. So you've got to make sure that the information is accurate. Never ever treat a search warrant like something that you can rubber stamp or that you should be cavalier about. Always remember all of the risk involved. So here's a picture of two of the important parts of a search warrant, the affidavit and the warrant itself. And they have different roles. All search warrants have 3 parts: an affidavit, the warrant itself, and the return of service. I've already posted on Canvas a number of sample search warrants for you, and you'll notice that they all have 3 parts, whether they are from the state of Texas or they're a federal warrant. Now, the affidavit, which is not actually part of the warrant, is where you have to establish probable cause that there's evidence of criminal activity in the place that you're searching. And once if the judge finds probable cause, then the judge may sign and issue that warrant. What's probable cause? Reasonable basis to believe is a good example I like to use. The example I've typed here is facts and circumstances sufficient to lead a reasonable and prudent person to conclude that a specific person has committed or is committing an offense. That gives us probable cause to arrest. But look at the second part that I put in yellow. Or specific property or items will be found at a particular place. Procedurally, Search warrants have to be issued by a magistrate, signed by a magistrate. If not, evidence may still be admissible under the good faith exception. Keep in mind, good faith is different in the state of Texas than it is federal, and I'll be happy to address that later when we meet in class. Search warrants also have the date and hour of issuance written on the warrant. A search warrant cannot be stale, it has to be timely. And in the state of Texas, it has to be issued in the name of the state of Texas. Substantively, specificity is everything. The Fourth Amendment demands that the place or person is described with specificity. The magistrate must be neutral or detached. So we're going to talk about those specificity requirements a little bit later, but I want to impress on you the importance of getting the information in a search warrant right. Think about how many main streets we have in this country. Think about drafting a search warrant that takes the police to an address and it's an apartment complex, or it's a storage unit, but you didn't decide, actually list which storage unit is involved. You've got to make sure that you are precise and right when you draft a search warrant. Now, we said that a search warrant has to be based on probable cause. Probable cause is contained in the affidavit. Let's turn now to the different sources of probable cause. One of the most common sources of PC is just the officer investigation. As long as the officer has the necessary training or experience, then they can just kind of put themselves in that probable cause statement affidavit, that they observed something, that they learned something, that they interacted, what have you. Confidential informants are also very, very popular sources of probable cause. Keep in mind that the presumption is one of unreliability. So the officer, in order to rebut that presumption, must actually put in the affidavit that the informant is reliable. So it may be something like the officer has worked with this informant on 20 other locations and the informant has always provided correct and accurate information that has led to blah, blah, blah. So you've got to make sure, if the officer is relying on a confidential informant, that he or she is able to bolster that confidential informant. Because when someone is hiding their identity, there's a presumption that that's not reliable information. Now, you may have a disinterested person. If they have nothing to gain, you would say that the affidavit, and you would say the name, is sufficient if the information is direct knowledge on his or based on his or her part. If the person wants to be anonymous, you then have to establish credibility. You can do that by talking about the years they've been in the community, how many years they've been gainfully employed, that they don't have any known criminal record, if they have a reputation for honesty. Don't let officers skip this step. If there's a witness that sees something, the officer needs to be able to somehow vouch for or highlight why they're credible and why their information should be believed. And then it's the statement against penal interest. If you have a confidential informant or defendant giving self-incriminating information, the presumption there, it is probably truthful. Now, this is different than when we're in trial or in court with the accomplice witness rule. That requires independent corroboration. But for probable cause for a search warrant, a statement against penal interest by a CI or a defendant is sufficient. The other source of probable cause would be an anonymous tip. Now, an anonymous tip by itself is not enough for probable cause. You need additional facts. And we saw this in the Illinois v. Gates case, where the investigating police officer received an anonymous letter that about some criminal activity. I believe it was drugs. And so that investigator actually conducted his own independent investigation, which corroborated the tip. So anytime you've got an anonymous tip, make sure the police didn't just go for it. That's why we've had a lot of tragic circumstances with some of these SWAT teams. I think they call it swatting, where people have called in false reports. So it's really important that the police do their diligence if there's an anonymous tip. So let's talk about the different perspectives. From the law enforcement perspective, if it's not described, it should not be searched. If they go into some place with a search warrant and they see something really interesting that they want to get into and it's not in the search warrant, they need to secure the scene and just get another warrant. That's the safest practical advice I can give, because ultimately you want to try to protect that evidence. Make sure you clearly define the scope of the search. Make sure you're being particular about your description of the place to be searched, persons or things to be seized. So some officers, especially if they're in a particular unit like homicide or major drugs, they do their own search warrants. So hopefully they'll know, but sometimes mistakes happen all the time. They can be particular with their descriptions by including a photograph or a diagram or the actual property address where it's lot number or whatever. But you want to make sure that it's very clear to whoever is going to follow through with that warrant that they go to the right location. What about the judicial perspective? From the judicial perspective, the judge has to be neutral. It has to be a common sense decision, and they have to look at the totality of the circumstances. Given all the circumstances in the affidavit, is there a fair probability that contraband or evidence of a crime will be found in a particular place? So for example, if someone presents me with a search warrant because they did an undercover buy bust 6 months ago, I actually don't have probable cause to believe that there will be evidence of drugs 6 months later, right? So they would have to do something to make that information more current. You also need to describe the place to be searched. And we've touched on this earlier, but I'll just highlight again. Physically, is there a red flower pot in front of the front door? Is there a doormat that says come back with a search warrant? Anything that you can say that makes the physical characteristics of the location stand out, you need to do so. Geographical information or an official description, but don't just rely on the address alone. Be as descriptive as possible. Send your officers out to the scene to actually look at it. Diagrams and photos are great. Just make sure you refer to those things in your affidavit, so it's included in the description. An example would be attached. I hate things like here too, but we'll go ahead and accept the legalese for the moment. Attached here too as Exhibit A is a diagram illustrating the relative location of the place to be searched. It is to be considered as part of this affidavit if written herein. So just make sure that you refer to it, and if you do, then that will work. Now, federal search warrants are covered by Rule 41 of the federal rules. A warrant may be issued under the federal system for evidence of a crime, contraband, including fruits or other items illegally possessed, property designed for use, intended for use, or used in committing a crime, or a person to be arrested, or a person who is unlawfully restrained. Texas search warrants are covered under Article 18 of the Code of Criminal Procedure. In Texas, you've got to have a magistrate. A magistrate, for our purposes, is essentially a judge. It can be a municipal court judge. It can be a judge from the Texas Supreme Court, Court of Criminal Appeals. That part doesn't matter. Keep in mind, for some of the smaller jurisdictions in Texas, it also includes mayors. So yes, a mayor can also sign off on a search warrant. Any magistrate can sign off on almost any warrant except mobile tracking devices, trap and trace, pin registers, wiretaps. Those have heightened privacy interests. Therefore, those can only be signed off by district court judges. The grounds for issuing needs to be PC to believe that items are in a particular place or on a particular person. And here's the important part: at the time of issuing the warrant. Remember my hypothetical about the undercover buy bust. If there is no reason to believe, no probable cause to believe that there's evidence of a crime at that moment when I'm signing it, I can't sign it. Same thing with the DWI blood warrant. If it was 18 hours later, I can't really justify that there's evidence of a crime at that place at the time. So Texas search warrants include items that independently can constitute contraband. Ordinary property that becomes evidence because of its evidentiary nature, like blood, and persons. Okay, so let me try that again. I apologize. So, in Texas search warrants, you can ask for a search warrant for things that are clearly contraband or for things that are not contraband, but because it's related to evidence, all of a sudden it has evidentiary value like blood, or for persons. So, 1802 is our laundry list that covers all the different things that can be searched for: theft, property for commission of an offense, arms and munitions, gambling devices, obscene materials, and so on, drug controlled substances. These are things that no one has a right to just have, right? So it's contraband. 1802.10 talks about property or items except personal writings by the accused that constitute evidence of an offense or constituting evidence tending to show that a particular person committed an offense. This is the mere evidence rule under 1802.10, where ordinary property or items that become evidence because it's related to a crime. So blood is not contraband. There's nothing illegal about blood, but blood can have evidentiary value if I'm suspected in a driving while intoxicated case because there may be evidence of my intoxication in my blood. That kind of evidence would be covered by the mere evidence warrant under 1802, subsection 10. And subsection 11 talks about persons. Now, it's rare because normally you just use an arrest warrant, but sometimes it's not that the person did anything wrong, but you need to find someone. Maybe they're in a constitutionally protected area. Maybe even you're looking for a body, but this will allow you to search for persons. Now, there are a couple other things in Texas that may not be in place in other places. One is the sneak and peek warrant. This, I've never been privy to it, but I know it happens and the law allows for it. It allows covert entry, which is sneak and peek, where officers can go into a place as long as it's unoccupied, search for the evidence, and leave without taking anything and without leaving a trace that they made entry. Now, if it's reasonably necessary, they can take the items. They call that a sneak and steal. Now, this kind of specialized warrant is justified anytime there's a concern on whether or not that evidence is on the target premises, and or if they reasonably believe that suspects may disrupt the investigation by destroying the evidence, threatening or killing witnesses, fleeing, or doing something that would truly damage the investigation. Once a search warrant is executed, the officer has to, by law, leave the inventory with the person or just leave it at the scene of the property. So remember, there are three parts to a search warrant, right? The affidavit, the warrant itself, and the return. So right now we're talking about the return. The warrant has to be returned with the written inventory of the property seized to the judicial officer. So no one comes back to me with property or evidence, but frequently people will come back with the return letting me know what they collected, and that's obviously going to be filed with the clerk. What happens if a search warrant is executed and the owner isn't there? Then whoever's in possession can get a copy. If no one is present, you have to leave the documents at the place. If you have kicked down the door, the police will be held liable if they don't re-secure the premises. So they can't just leave it open for other people to burglarize and destroy your home. And then seize property. Although the article says that seized property should be carried before the magistrate, practically speaking, this is constructive delivery. I don't see any property. So that's it for our discussion in preparation for our live class lecture on search warrants. We're going to have some exercises, guest speakers. It's going to be a great class. If you have any questions about this lecture or anything else, please let me know.